Okay, part two of the defense, still doing our closing.
Sentences from the instruction and why you must read the instruction carefully. Yes, the defendant is criminally liable for all of the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes. If such intervening causes were the natural result of the defendant's act. Okay? So if the intervening causes were the natural consequences of the defendant's acts, he's liable. So think about it in this example. Police officer arrests somebody. He puts that person on a hot August afternoon in the backseat of a squad car, rolls up the window, turns on the heat, and leaves the person in there, right? Person dies of a heat stroke. Officer put him in there and is responsible for the natural consequences of his actions. But consider the situation where police officer arrests someone, they're compliant, they go into the backseat of the squad car, they're sitting in the backseat of the squad car, and they have a heart attack. They have a pulmonary embolism. They have a brain aneurysm. Something happens to that person that was not the natural consequence of being arrested. It was just a physiological something that happened to that individual. The officer is not liable because it's not in the natural course of events. And it's not the result, the natural result of the defendant's act. Right? So again, read the entire instruction. The significance of this instruction, again, is that it goes through all of the three charges. You have to be convinced that the defendant's actions caused the death of Mr. Floyd. And throughout the course of this trial, the state has tried and called numerous witnesses to try to convince you that asphyxiation is the singular cause of death. The singular cause of death. And why is that? It's because actions that happened before Mr. Floyd was arrested that had nothing to do with Officer Chauvin's activities are not the natural consequences of the defendant's actions. You have to focus on the consequence of the defendant's acts. And so the state has tried to convince you beyond a reasonable doubt that the stress of being arrested and the adrenaline produced as a result of Mr. Floyd's physical resistance played no role. This is what they have to try to convince you. There's no role of that physical exertion. Played no role in this death. They're trying to convince you beyond a reasonable doubt that Mr. Floyd's heart disease played no role in this case. The state must try to convince you beyond a reasonable doubt that Mr. Floyd's history of hypertension played absolutely no role in the cause of Mr. Floyd's death. The state must convince you beyond a reasonable doubt that Mr. Floyd was not experiencing excited delirium that contributed to the cause of his death. The state has to convince you beyond a reasonable doubt that Mr. Floyd's paraganglioma was not contributing to the cause of death. The state must convince you beyond a reasonable doubt that Mr. Floyd's toxicology played no role in his death. Right? The state would have to convince you beyond a reasonable doubt that a combination of these pre-existing issues did not contribute to Mr. Floyd's death. That is why the state has brought in.
I wish he'd have brought the drugs. He left out the drug, the poly drug use, the nicotine. He was a smoker. He had caffeine. He was taking anti-opiate drugs for his. I wish he'd have drove the drugs a little more here.
Expert after expert after expert to testify that the singular cause of death here is asphyxiation. Because if Mr. Floyd was asphyxiated as a result of the police restraint, he is liable for the natural consequences of that restraint, of his actions. But if any of these other factors come into it, if any of these other factors were substantial contributing factors of Mr. Floyd's death, because they were not the natural result of the restraint. If a person has drugs in their system and that drug causes an overdose in the context of the police restraint, it's not the natural consequence of the restraint, it's the natural consequence of the deceased's actions. So the state has called 6 experts, really 5, but I'll include Dr. Baker. The state first called Dr. Tobin, a pulmonologist. Dr. Tobin said that you need to apply common sense exclusively from positional asphyxia. Coronary artery disease, hypertension, controlled substances, they played absolutely no role in the death, according to Dr. Tobin. The state called Dr. Eisenschmidt, a toxicologist, to explain to you that Mr. Floyd's toxicological levels were somehow more consistent with a DWI case than a whole bunch of other cases that may or may not have involved an overdose, right? Remember the ratio where he said, well, no, these are cases, they may have died of something else. They may have died of a gunshot wound, but they had fentanyl in their system. So he gave you these strange statistics, but essentially attempting to try to convince you that these levels are insignificant. People drive their cars around, right? And that therefore the drugs played no role in the death of Mr. Floyd. Third, the state called Dr. Smock, an emergency room physician, right, to explain to you that Mr. Floyd was not experiencing any symptoms of excited delirium. And that coronary artery disease, hypertension, controlled substances, none of that comes into play. He called Dr. Thomas, a pathologist, to testify how she interpreted what Dr. Baker meant. How she concluded that Dr. Baker simply said that the cardiopulmonary arrest is the basic way everybody dies. And she interpreted the reason why Dr. Baker put those factors on his autopsy or on the death certificate were merely for statistical purposes. You put stuff, the CDC requires us to put that stuff on there. And it was an asphyxial death. Controlled substances played no role. Hypertension played no role. Coronary artery disease played no role. They did call Dr. Baker. We'll talk about Dr. Baker in a minute. And finally, the state called Dr. Rich, a cardiologist who concluded that despite a 90% narrowing of the right coronary artery and a 75% narrowing in the left anterior descending artery, despite an enlarged heart and a history of hypertension, that Mr. Floyd had a strong heart, and that none of those pre-existing and coexisting conditions in any way contributed to the death.
That's a really great point, because anybody with a brain knows those doctors were just totally singing whatever the prosecution told them he wanted. I mean, it was just ridiculous. And if you can discount one thing from an expert or from a witness, you're entitled to discount everything they say.
Of Mr. Floyd. It flies in the absolute face of reason and common sense. It's astounding, especially when you consider the actual findings of Dr. Baker, right? Because Dr. Baker is the only person who actually performed the autopsy in this case. He's the only person who performed the actual autopsy. He told you that he specifically avoided watching the video because he didn't want to bias or influence his autopsy. He specifically testified that there was no evidence of asphyxia. There were no evidence of petechial hemorrhaging. There was no bruising to the neck or back above the skin, under the skin, or into the subcutaneous muscles of the neck and back. And he would expect to see those things in a case like this. There was no finding that pressure was applied to the point of Mr. Beck to cause these injuries. There were no injuries to the structures of his neck, and that when he finally did review the video, it didn't appear that the placement of the knee affected the structures of the neck because Mr. Floyd could lift up his head, turn his head, move it around. He saw no fractures to the structures of the neck, including the hyoid bone. There were no soft tissue injuries to the sides of Mr. Floyd's neck. There was no hemorrhaging or injury to the hypopharynx. No evidence of life-threatening injury to the neck or spinal column of Mr. Floyd. There was pulmonary edema, which is the swelling of the lungs, which could be caused by the resuscitative efforts or fentanyl. There's no evidence of hypoxic changes to the brain. There's no evidence of any brain injury consistent with an asphyxia death. He found a paraganglioma, and he said it was an incidental finding. He said his heart was enlarged. Mr. Floyd's heart was enlarged, right? Dr. Baker, Dr. Thomas, Dr. Rich, and Dr. Fowler all agreed. He found narrowing of the right coronary artery, 90% narrowing. He found 75% narrowing of the left anterior descending artery. He's the person who did he sent out the toxicology samples. Fentanyl level at 11 nanograms per milliliter. Methamphetamine at 0.19 per millimeter. all of these findings that are ultimately relied upon by all of these other experts were done by Dr. Baker. He determined that the manner of death was a homicide, right? Homicide. It is to be emphasized that the classification of homicide for the purposes of the death certificate is a neutral term and neither indicates nor implies criminal intent, which remains a determination within the province of the legal processes, right? The fact that he found this a homicide is a medical term. Dr. Fowler talked about the undetermined manner. It is no more compelling than one or more other reinforcement, subdual, neck restraint, and neck compression. Other contributing factors are arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The term complicated in this is important because Dr. Baker was able to give you what he said his actual intent was, right? Dr. Thomas speculated about what she thought Dr. Baker meant. Dr. Baker was able to tell you what he meant. He untoward outcome on the heels of that intervention. And he gave you a specific example. He described a person having a hip surgery and a blood clot comes loose, and that blood clot causes a death. The hip surgery didn't cause the death. The death was caused by the blood clot that complicated the surgery. So as I understand his testimony, what Dr. Baker was saying was that there was an unexpected result. The death of Mr. Floyd occurred during an event where you would not generally expect such a complication, subdual and restraint. He specifically testified, Dr. Baker specifically testified that if he put it on the death certificate, it played a role in the death. If something is insignificant to death, you don't put it on the death certificate. So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death of Mr. Floyd. Dr. Baker concluded that Mr. Floyd's fentanyl intoxication played a role. Dr. Baker concluded that Mr. Floyd's recent methamphetamine use played a role. Right? Dr. Baker described that this death of Mr. Floyd was a multifactorial process. A multifactorial process is how he defined it.
He's making some great points. I mean, this is clearly what the jury should be paying attention to, but the defense has lied so much and played the video so many times and made George Floyd out to be St. George. They're going to name a church after him. It's almost criminal what the prosecution did.
No single factor, one over the other, played any more of a role resulting in Mr. Floyd. Wants you to believe what you see. And they did not like Dr. Baker's conclusions. June, July, by August, talk to a pulmonologist, talk to an emergency room doctor, not within my area of expertise, talk to a cardiologist, right? His findings didn't support the notion that what you see is what you should believe. The information that Dr. Baker has concluded were found during the actual autopsy. Dr. Tobin concluded emphatically that Mr. Floyd's death was the result of positional asphyxia, right? The pressure of the asphalt, pressure of the weight of the officers, positions, all of this resulted in hypoxia, low oxygen to the brain. Mr. Floyd was asphyxiated through positional asphyxia. More carefully analyzed. Testimony. He described what he interpreted this was basically Mr. Floyd trying to push himself up onto his left side to free the right lung to help him breathe. Look at the timestamp of the photos taken from the body-worn camera here. They were taken at 8:19:35, 15 seconds after Mr. Floyd was placed on the ground. Yet Dr. Tobin also explained that Mr. Floyd went on to breathe for an additional 5 minutes and 51 seconds until he took his last breath at 8:25. He neglects the fact that at this point, this is the point that we just saw, when Mr. Floyd is taken out of the car and he is actually in the side recovery position for about the first 2 minutes of this 9 minutes and 29 seconds. Not moving.
Mama. Mama.
Yeah,
Mama. Mama.
one of the front couches.
Mama.
On my right side bed.
Mama. Mama.
You're this guy.
All right. All right. Oh my God.
Sorry, put the
I
chair
can't believe this. I can't believe this. I can't believe this. I can't believe this, man. Mama, I love you. Reese, I love you.
You got mama?
Get my kids, I love them. I'm dead.
My site's listed.
Man, that's a good point. They never showed the video. They only showed the still footage. They made it seem like it was a last grasp effort that he put his knuckle there. And he's actually on his side right now. You can see his shoulders off the ground. That's a good point.
I can't breathe for nothing, man. Please. Please let me stay in.
No. Just leave him.
Of time in this arrest. You can have this testimony that he's pushing his body up to try to breathe, right? But when you look at the evidence compared to the rest of the evidence, what do you really see? You see a person who is on his side, being held in the side recovery position, whose hand is touching the ground and the tire at times, the totality. 0.5 pounds of pressure to the neck of Mr. Floyd. So let's look at this time in the context of the other evidence.
His whole nose.
Why you just sitting there? He ain't doing nothing now. Put him in the car.
How long y'all gotta hold him down?
Why we don't do drugs, kids? It ain't about drugs, bro. I understand that.
Did anybody even see the toke him up off the ground? I mean, was it half a second, a quarter of a second? Right? But when you take a single incident, a frame, a single frame, and you add the drama, and you make all of the assumptions, right? Officer Chauvin's body weight,
Great point.
Mr. Floyd's EELV. He's the only person who calculated the EELV based upon the presumptions of health, based upon studies, based upon theory. All of this information, you can put this into a single frame, but you have to analyze the evidence in the broader context. You can also see during the clip that Officer Chauvin actually is sort of adjusted forward and touches this car. Right? You can make a lot of informed decisions about how is he shifted. If I'm shifting my weight this way, majority of my weight is shifting on my left foot. If I'm this way, it's on my right foot. You watch this video and you can see the dynamic shifting. Help side. And remember, he said he spent 150 hours analyzing this thing. His entire testimony is filled with theory, speculation, assumption. Do not let yourselves be misled by a single still frame image. Put the evidence in its proper. This was an overdose death, right? It's a multifactorial process, as Dr. Baker said. So we have to look at what role does the toxicology play in this case. And you need, because again, we had Dr. Eisenschmidt who testified that he found that the levels of fentanyl and methamphetamine were more consistent with this DUI population. But what do we know about the actual toxicology? There were 11 nanograms per milliliter of fentanyl and 0.19 nanograms of methamphetamine. Those are the principal two findings. And additionally, what we know is that the byproduct of methamphetamine, which is amphetamine, was not reported at the levels. Doesn't mean it wasn't technically there, but it was not reported. So it's below threshold reporting values, which signifies that the methamphetamine use was recent. Hence, in Dr. Baker's death certificate, he included the recent methamphetamine use because there was no amphetamine. The history of Mr. Floyd's use of controlled substances, it is significant. It's not a character problem. Millions of Americans suffer from the opioid crisis, right? I mean, it is a true crisis that this country is facing. But it is significant to understand the history, not just as much as the long-term history, but his long-term history provides us with insight on how his body physically reacts to methamphetamine or opioid use, I should.
This would be a great point to say. You heard the prosecution talk about tolerances. How do you think tolerances get so high? because it's used, the drug is used so often and so frequently, and you always require more and more, and the body builds tolerance. That indicates that the prosecution said he had a high tolerance because he had extensive long-term use of the drug.
Say opioid use within the context of a law enforcement encounter. We know from the testimony of Courtney Ross that Mr. Floyd struggled. We know he had been using controlled substances habitually for some time. We know that on May 6th of 2019, during an encounter with the police, Mr. Floyd ingested some controlled substances, said they were Percocets. He was startled by the police, like he was in this case. Officer drew his gun in that case too. And that resulted in a blood pressure of 216/160. I mean, that's not just high. That is skyrocketing high. We know from Ms. Ross that in March of 2020, they purchased some pills that were supposed to be Percocets, an opioid. We know from Ms. Ross that in March of 2020, Mr. Floyd was seen for a drug overdose. She described how he felt in that instance. She said his whole body hurt, his stomach hurt. We know, based on again from Ms. Ross, that he was clean and sober for some time while they were in quarantine. Right? She said she felt like she was going to die. We know Mr. Floyd was with Maurice Hall on May 25th, 2020. We heard from the store clerk, Christopher Martin. He described Mr. Floyd as being high. We heard from Shawanda Hill that when they got back into the car, right, they had a conversation for a few minutes, and suddenly Mr. Floyd fell asleep. All of these things become important. That he had trouble. They had trouble waking him up. She called her daughter for a ride because they couldn't wake Mr. Floyd up. They couldn't keep him awake. We heard how Mr. Martin described Mr. Floyd when he went back to the car, and how he was, oh no, and he wasn't speaking, right? He kept putting his head back and shaking his head. We can also see he was eating a banana. Right? He bought a banana.
I never saw him eating a banana. Matter of fact, I never see him bought the banana. I saw him grab it and carry it out. Oh, there it is in his hand. Okay.
There's something in Mr. Floyd's mouth. Is it gum? Is it banana? Is it drugs? Nobody knows, right? But regardless of whether it's drugs, bananas, or gum in this incident, we know that there were pills in the car. What was in Mr. Floyd's system?
That's the stuff that the state's fine officer that did an inventory of the vehicle missed. That female with all the education left those in there. Those would have never been found unless the defense went in and did a second observation and saw them and said, why weren't those taken?
We know at some point Mr. Floyd was handcuffed. His hands were behind his back. It would have been physically impossible to put anything in his mouth at that point. And we know that in the squad car, 320 were pills. We know those pills were analyzed. We know those pills consisted of fentanyl and methamphetamine. We know that Mr. Floyd's salivary DNA was found on those pills. This is from the Minneapolis Police Department strain. Approximately 2 to 3 milligrams. Smaller than a penny. This is from the squad car. You can look at these pictures closely during the course of your evidence. Is being subdued by and through the windows. We watched it, and then he throws something. Right? We know that Mr. Floyd had drugs in his mouth. We know that some percentage of that would have been consumed and absorbed into his system. We don't know how much he took before, right? We don't know when he took an earlier dose in relation because fentanyl had actually started to metabolize in his, so fentanyl was longer before. For the medical experts to minimize the timing and the amount of illicit drugs that were found in Mr. Floyd's bloodstream, it is just simply incredible to me.
It is. It's flat out lying. I mean, it is just, and there's a thing that's called suborning perjury. And that's where an attorney puts somebody on a stand to intentionally lie when the attorney knows it's a lie. And I mean, these doctors are literally a perfect example of a DA suborning perjury, saying, I don't care if it's true. You just get up there as an expert and say what helps me. It's just outrageous.
It is incredible to me. Every single doctor testified that that the absence of signs of fentanyl overdose weren't present because he was alert, he was talking. But it ignores what Shawanda Hill and Maurice Hall says, right? That he was all of a sudden asleep and difficult to wake up. It ignores the fact that the combination of these two drugs, methamphetamine is a powerful stimulant. Fentanyl is a powerful sedative. They use it for surgeries. Every single doctor dismissed outright. No, nothing about this case. Well, it was only 0.19 nanograms per milliliter. It's such a small amount of methamphetamine in his system. It's a vasoconstrictor. It causes the heart's arteries to constrict even tighter. Doesn't matter. Every single doctor just brushed it aside, said it would have no effect. I ask, would any of those doctors prescribe illicit methamphetamine to their patients? Would they give it to their children? Would they give it to their elderly parents with a 90% blockage of the coronary artery, the right coronary artery?
Of course not.
I guarantee you the answer is no. Dr. Rich is the only one who said, I would never recommend to my patients that they take any amount of illicit methamphetamine. It is preposterous. That it's a preposterous notion that this did not come into play here.
Half-hour break for lunch. I don't want to interrupt your argument, but
I apologize.
members of the jury, 30 minutes for lunch, please. Thank you.
Alrighty, I guess they're breaking for lunch. Okay, and we're after lunch?
Talking about the controlled substances and the role that they were the levels that they were found in, the role that they may have applied or contributed to Mr. Floyd's death. And I was suggesting to you that it is, again, this death needs to be looked at. Mr. Floyd's death needs to be looked at, as Dr. Baker describes, a multifactorial process. This is the way the human body works. The heart beats, the lung breathes, the blood circulates, the brain thinks, the brain controls all of our movements, right? All of this. And to simply come in and say, this particular substance or these combinations of substances, when taken in combination with each other, when taken in combination with a person who has blockage in the heart, substantial, significant blockage in the heart, when we know that these drugs play a particular role in how the blood circulates, to just poo-poo it and say it has nothing to do with anything is just really a preposterous notion. Yet Dr. Baker, Dr. Fowler, and Dr. Thomas have all certified deaths at levels less than 11 nanograms per milliliter or 19 nanograms or combination, right? These deaths have been certified on that basis alone, and it didn't necessarily contain any of the other issues that were confronting Mr. Floyd on that day. It's gone to great lengths to dismiss the role of Mr. Floyd's heart disease and define coronary artery disease resulting in death. Death can occur with 70 to 75% blockage. Has indicated likewise that they have certified deaths with those types of blockage, played zero role. Dr. Rich testified Mr. Floyd had a healthy heart. Not relevant. Not relevant.
I think you should bring up, because the prosecution kept going about nonsense, common sense, and nonsense. He should be using those terms when he's talking about these doctors lying. Prosecution talked about common sense and nonsense. This is nonsense that none of those factors played a role.
Adrenaline coursing through Mr. Floyd's body, not relevant. What does adrenaline do? It further constricts the arteries, right? Adrenaline from the paraganglioma wasn't there, didn't happen, played no role. They just want you to ignore significant medical issues that presented to any possibility at all that any of these other factors in any way contributed to Mr. Floyd's death defies medical science, and it defies common sense and reason. And again, to hypoxia, low oxygen resulting in going to the brain, low oxygen to the brain. Dr. Fowler also ascribes the death to hypoxic death, but that the heart was the muscle that did not get the oxygen.
Now, you got to realize the public pressure, this case was brought on by public pressure, riots, to stop riots, threats, terrorism, whatever you want to call, burn, loot, murder, people out there threatening to burn down a city if this guy is in charge. So when the prosecution is faced at charging somebody and they've got a crap case and they know it shouldn't be charged, but they don't have the integrity to say, we're not charging this. It's just not right. I don't care what the consequences are. We don't charge because people are going to threaten us. Instead of doing that, they had to make a case. So what was their case? We're going to say he died of asphyxia and all these other problems don't matter. And we'll find witnesses to support that, and we'll lie to the jury, and we'll waste money, and we'll put on this false charge. And then when we don't get a conviction, we'll blame it on the defense, or we'll blame it on the judge, or we'll blame it on the jury, or we'll blame... It's just ridiculous.
Resulting in a sudden cardiac arrhythmia. The reasons that Dr. Fowler dismissed the notion of brain hypoxia are because, number one, hypoxia of the brain results in certain observable symptoms. The brain demands more oxygen, right? It takes 20% of our oxygen to function the brain, even though it's a smaller percentage of our body. It is the most sensitive to the loss of oxygen, and it reveals a progressive set of symptoms. Confusion, which was not exhibited, right? Because if you compare the testimony about whether Mr. Floyd was intoxicated, well, he didn't exhibit any confusion, right? Restlessness, not exhibited. Shortness of breath, it was complained of, but that is also a sensation that can be caused by a sudden cardiac arrhythmia. Visual changes, not complained of. Incoherent speaking, not complained of. When someone is experiencing hypoxia to the brain, as Dr. Tobin stated, you would see an increased ventilation or respiratory rate. At 8:23 and 58 seconds, Mr. Floyd speaks. I really can't breathe. If you can speak, you have oxygen in your brain. Stating at 8:24:09 that his brain has oxygen and there is no impairment to his airway. 39 seconds later, Mr. Floyd goes limp at 8:24 and 48. A person can hold their breath for 39 seconds, right? That does not result in hypoxia in 39 seconds. 27 seconds later, according to Dr. Tobin, Mr. Floyd takes his last breath. It's a total of 66 seconds, 1 minute and 6 seconds from the time that we know there's enough oxygen in his brain to speak. No occlusion to the airway at that point. 66 seconds from his last word to his last breath. This timeline is consistent with a sudden cardiac arrhythmia. It is not consistent with the longer process of brain hypoxia. Restraint by police. Other significant factors: fentanyl intoxication, methamphetamine intoxication, possible CO, carbon monoxide exposure, and the paraganglioma. What role did carbon monoxide play in Mr. Floyd's death? We don't know. Nothing was ever tested. As far as the vehicle is concerned, we don't know if the car was emitting carbon dioxide.
Okay, he had to correct that because there was a test. They just couldn't get it in. So now he corrected the vehicle wasn't tested. So if they say you misrepresented and said it was never tested, he can say, I was referring to the vehicle. Good catch.
Carbon monoxide, we don't know. One thing we do know is that it was running. And how can we tell that it was running? Because in the video we watched earlier, when Thomas Lane pulls in that squad car at Cup Foods, he puts it in gear, he takes it out of gear, he puts it in park. He never touches the keys of that vehicle, and he gets out. The car was running.
Oh, I didn't know that. That's a good point. I think he should have pointed that out earlier.
I have one last point to make, and I should be fairly quick with this. The superseding cause that was discussed. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not have otherwise occurred. Now, let's look at the medical timeline here. We know that EMS was called initially at code 2 at 8:20 and 11 seconds. We know that EMS was stepped up to code 3 at 8:21 and 35 seconds. We know that
This is when you need a draft, something on a board that I can see these numbers and refer and jump back and forth. Just rattling them off doesn't do the same as being able to look at them.
EMS responded to Cub Foods, based on the videos, at 8:27 and 27 seconds. We know that EMS called for fire at 20:38, 36. It takes approximately 3 minutes for EMS and the arresting officers to put Mr. Floyd into the ambulance, and the ambulance pulls away from Cup Foods at 8:30 and 17 seconds. Fire responds to Cup Foods at 8:32:59. That's 4 minutes and 15 seconds after they were called. That's pretty close in consideration to the 3-minute expectation of Ms. Hansen. But the ambulance had driven several blocks away to 36th and Park, arriving sometime between 8:31 and 8:33. That's 1.5, and we know that because there are 2 exhibits, 62 and 63, that were introduced. 62 shows 1 paramedic and Officer Lane in the back. 63 shows 2 paramedics and Officer Lane in the back. So somewhere between 1.5 to 3 minutes to get to 36th and Park, where they began the resuscitative efforts. The first air is pumped into Mr. Floyd, per Dr. Tobin, at 20:35:06. That is 10 minutes after Mr. Floyd went unconscious, per Dr. Tobin, but it is 7 minutes and 46 seconds after EMS responded to Cup Foods. We ultimately know that the ambulance left 36th and Park at 8:48 and 23 minutes. It arrived at HCMC at 8:53, shortly after 8:53. So it took about 5 minutes to get from 36th and Park.
He didn't mention the load and go. I think the load and go is important because the ambulance showed up and even they felt the crowd was a threat and they didn't want to risk working on him there, which delayed the care. And they observed that as being ambulance drivers, not as trained police officers. So that would corroborate why police officers thought the crowd was that. That would have been a good point.
Park to HCMC. What would have happened if EMS had started resuscitative efforts right away? What would have happened if, rather than driving to 36th and Park, they went to the hospital? They would have been there in that time. I am not suggesting to you that the ambulance paramedics did anything wrong. But it raises the prospect of that continued delay in resuscitation. What if EMS had administered Narcan? We heard that it would not have hurt him, and it could have helped him. I'm not blaming the paramedics. More importantly than this analysis is,
he's not blaming paramedics, but he has to make a point that all those things were out of Chauvin's control. He couldn't change any of those things, and yet he's being held accountable because of George Floyd's death, and nothing else or nobody else is.
it shows that human beings make decisions in highly stressful situations that they believe to be right in the very moment it is occurring. There's lots of what ifs that could have happened, what could have happened, what should have happened. Lots of them in lots of regards.
Man, if he busted out with if and buts and coconuts right now, I'd be like, yeah!
We have to analyze this case from the perspective of a reasonable police officer at the precise moment with the totality of the circumstances when it comes to the use of force. We have to look at the cause of death to determine, did Mr. Floyd die exclusively of asphyxia, or were there other contributing factors that were not the natural result of Mr. Chauvin's acts? Right? Things that happened that were set in motion before Mr. Chauvin ever arrived. The drug ingestion, right? The bad heart, the diseased heart, the hypertension. All of these things existed before Mr. Chauvin arrived. The struggle, what role did the struggle play? We know, based on a prior incident, that Mr. Floyd's heart was beating at 219 over 160 in a situation where he was confronted by police and had ingested drugs. He didn't die that day. All of this, ladies and gentlemen of the jury, all of this, when you take into consideration the presumption of innocence, the presumption
Reasonable
of innocence
doubt.
and proof beyond a reasonable doubt, I would submit to you that it is nonsense to suggest that none of these other
Oh, he finally used the nonsense. Good.
factors had any role. That is not reasonable. And when you, as members of the jury, conclude your analysis of the evidence, when you review the entirety of the evidence, when you review the law as written, and you conclude it all within a thorough, honest analysis, the state has failed to prove its case beyond a reasonable doubt. And therefore, Mr. Chauvin should be found not guilty of all counts.
Okay, so we're done with the defense. Now the prosecution gets their second bite at the apple, and they're going to use the DA, which I think is a horrible DA to use, the one that got all upset. But he's going to come back and drive home the heart and the lungs and all this other crap. But he's just uncredible, and I can't believe they're letting him do a closing. They're probably doing it so they won't be called the mean R word or something. But let's see what they're arguing about before they let him get up here.
Anybody, technical issue? Instead of the PowerPoint.
Your Honor, the state requests a curative instruction as to the issue of intent. I believe that the counsel made a misstatement of law when he indicated and argued that the defendant had to intend to apply unlawful force, as in he had to intend that the force he was applying to be unlawful. That's not a correct statement of the law pursuant to Dorn at 887 Northwest 2nd, 826. The state need not show that.
So by doing this, again, we're attacking the defense. We're making it look like he's doing something wrong or inappropriate. And then we're going to put our attorney up there to say all our stuff again. They got the jury instruction. I mean, the judge should say, look, I read the jury instruction. If he misstated it, the jury is not supposed to, they've already been warned not to listen to us and to make sure and refer to the evidence, their best recollection, and the copy of the jury instructions, what they were given. So I don't think he ought to do this, but he can't unring that bell. He's making his point whether or not the judge decides to do it or not. I think this should have been out of the presence of the jury, but it wasn't. Look at all the government trying to hang him. Anyway.
The defendant meant to or knew that she would violate the law. But that is what Mr. Nelson argued before the jury. And so we're requesting the court give a curative instruction to the jury as follows: that it is not necessary for the state to prove that the defendant intended to act unlawfully, only that the defendant intentionally applied force to another, that this application of force was unlawful, and that this application of force resulted in bodily harm. I believe that is a correct statement of the law.
Now, so all the good points that this defense attorney just made and that the jury might be thinking about, they're not thinking about now. He has totally redirected their attention to some legal mumbo jumbo about a misstatement of a jury instruction that they have a copy of. And now the jury is kind of wondering what's going on. I wonder why. I wonder how the judge is going to rule. I wonder if he did it on purpose. I wonder what. So he's totally got them stop thinking about his closing. Sleazy lawyer tricks.
Which is contrary to what the court instructed in the first set of instructions.
Your Honor, I believe the court's instruction was that the intentional infliction of bodily harm requires the proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. You did not instruct that the defendant need to intend that his force be unlawful, merely that he intended to apply the force, which was unlawful.
I'm going to deny the request for curative instructions. I will reread before the beginning of rebuttal statements of judge and attorneys, which starts at the bottom of page 2 and goes on to page 3, which specifically states that if an attorney's argument contains any statement of the law...
Oh, maybe the jury is out of there. The way they're talking, it doesn't seem like the jury's there.
...that differs from the law, I give you disregard the attorney's statement. I'll reread that, turn it over to Mr. Blackwell, who I assume will answer this exact question, or this exact issue in his rebuttal.
We do ask the court's guidance on another issue, and that is when Mr. Nelson argued, quote, Mr. Chauvin thought that he was following his training. There was no testimony from Mr. Chauvin, and he didn't argue that they could infer that. He argued that they thought that. Placing that in context puts us in a difficult position in that we can't comment on his failure to testify, but that statement is...
Okay, now I know the jury isn't there. Because if he said that in front of the jury, shit would hit the fan. So now I know the jury isn't there.
directly at odds with the evidence in the record.
Mr. Nelson, any response?
Read the quote, Steve. Excuse me,
So Mr. Chauvin thought he was following his training.
What was the context I said that in?
Well, it was in your use of force discussion, and you were talking about a reasonable officer following his training. You indicated that Mr. Chauvin thought he was following his training.
I don't recall saying it, Your Honor. I mean,
It was drowned out by a reasonable officer. I think it's a reasonable inference to draw from the evidence that exists. Even his statement to Mr. McMillan essentially was an indirect way of saying he was following his training. It's a reasonable inference for counsel to argue from the evidence. And to respond to that specifically by saying there's no evidence would in fact be commenting on his right to remain silent. So the bind the state is always in. So, but as far as the other issues, you can talk about requoting what the elements are on assault in the third degree, and also anything else that you think was a misstatement of law. I will read them, the statements of judges and attorneys, if you wish. And actually, before I do that, do you want me to read that? Reread that, or should I?
Yes, Your Honor.
Okay. I don't want to force it on you, but that would be is to remind them that any statement of the law that differs from mine should be disregarded.
And I would also ask that you reread the instruction on causation, because I believe that what Mr. Nelson argued was that the state is required to prove beyond a reasonable doubt that the other issues that he spoke about had no effect, right, had no causal connection, and that is not the law.
I'm not going to single out that instruction and re-instruct on that. I'm just going to read him the general one, and that if it differs, and I'm sure Mr. Blackwell is going to point out in great detail how Mr. Nelson misstated that.
Yes, Your Honor.
All right, bring the jury back.
Okay, so they're going to bring it in, and we'll start with the second closing from the prosecution.